federal judge rules against the NCAA.
NIL and NCAA lawsuits are always in the news, so we're back on the big mountain to keep you updated.
Hey, it's good to have you here on the mountain. I am JY, and this is my good friend Steve. We welcome you if you're new to our channel, and of course, we especially welcome our subscribers back. Steve had some really breaking news at the end of last week that we have got to get to. The United States District Court, Eastern District of Tennessee, the Knoxville Division, came out, or a judge came out in the case, the plaintiff here being the state of Tennessee and the Commonwealth of Virginia, the defendant being the NCAA, and they, go through. I'm going to go through the order here in total, and then I want to get your take on all of this stuff because this is right down in your wheelhouse. Yeah. So I'm going to throw this up. You can read along with me. We're just going to go over the very first paragraph in terms of the opinion and order here. So in July 2021, the National Collegiate Athletic Association drastically changed the landscape of college athletics by allowing student athletes to earn compensation for their name, image, and likeness. Naturally, this opened the floodgates, and a collegiate NIL market formed overnight. For some athletes facilitated their own NIL deals, but fans, alumni, and businesses also recognized an opportunity in the market and started forming NIL collectives to facilitate deals for their school's athletes. Problems began to arise, however, when the NCAA realized that these third-party collectives could offer NIL deals to induce student athletes to commit to a particular school. In an apparent attempt to prohibit those inducements, the NCAA issued guidance classifying NIL collectives as boosters to prevent them from negotiating with student athletes during the recruiting and transfer processes. For the reasons stated herein, the NCAA's prohibition likely violates federal antitrust law and harms student athletes. Accordingly, plaintiffs, state of Tennessee and Commonwealth of Virginia, who initiated this action on behalf of their student athletes, are entitled to a preliminary injunction enjoining enforcement of the NCAA's NIL recruiting ban. Steve, this comes just after a TRO was denied. This is now an actual preliminary injunction. Steve, you've read through this in detail. I want to know what you have to say. What stands out for you?
Yeah, I read all 13 pages, so you don't have to. But all joking aside, there's some really, really interesting parts, and just in this first paragraph that you read. Mm-hmm. So, first of all, it's important to kind of understand, July 2021, the NCAA, they were getting kind of attacked on all sides. Different states were creating their own laws, and instead of them just saying, hey, you know what, states have these different laws, we're just not going to regulate NIL, you guys should all follow your own state laws, they decided to kind of give guidance on NIL. Mm-hmm. And really, they just kind of opened the floodgates, but the one stipulation, the major stipulation was that the school couldn't participate directly.
Right.
And so that was, just they opened the floodgates. That's the caveat. The school can't participate. They got to, go through third parties, whatever, to get their NIL deals. Okay. But the floodgates were open.
Yep.
So at some point, after they had already opened these floodgates, they decided, we don't like this because we have these collectives. And these collectives are raising money together. And the collectives are not necessarily part of the school, but obviously they're loosely affiliated with a school in some way.
Yep.
So they tried to put the toothpaste back in the tube and say, hey, after, everything had been going on, these collectives were ramping up, coming up with deals, giving players money. All this was going on, and the NCAA, they're like, well, actually, we're going to step in now, and we're going to create some rules. We're going to say these collectives are actually boosters, and so they cannot participate in this process because that would be an incentive for you to come there. Well, that when they did this, it was already, the actions were already going on unhindered, and a lot of the NCAA at the same time said, you have these restrictions, but also we're not going to say anything against state laws. Okay,
Right.
if you have state laws that says you can do this or you can do that, that's going to take priority. So okay, so now you have, for the last 3 years now, you have all of these schools that are just operating willy nilly. The floodgates are open. They've created these separate collectives. And they've come up with creative wording to not be incentives as far as coming to their school. So they can't say, the collectives, and they've gotten good at this, the collectives can't say, hey, if you come to Florida State, come to Penn State, you come to Texas, we'll give you this amount of money. They'll say, well, players on this team generally make about this amount of money. So the player comes there, and their expectation is that they get that amount of money.
Right.
Now, we've seen cases, Texas A&M and some other schools, where players showed up, they thought they were going to get a certain amount of money, wasn't necessarily promised to them or contract in writing, and they didn't get that amount of money. Right. So we've seen it. So sometimes they get the money, sometimes they don't. So basically, with this ruling, they're saying that the NCAA, to come back in here and add these rules kind of post hoc after the fact, they're very clear on here. The NCAA's prohibition likely violates federal antitrust law and harms student athletes. So that's kind of the part. The NCAA started this on their own. That jumps out to me. And then you have a court ruling in here, and this is a preliminary injunction. But the court is saying, hey, what the NCAA, it sure looks like they are violating federal antitrust laws, so we are going to grant this preliminary injunction.
Yeah.
What do you have any comments on that?
Yeah, well, I don't have any comments yet. I'm going to have some comments, I think, as you get into this. I did find it interesting that not too long ago there wasn't an injunction ruled, but now it comes out that there is. So I was anxious to kind of get into some of the details and see what changed, because in terms of the case, nothing really changed. But as you read this, and I know you're going to get into this, I won't step on your toes here. But it was interesting to see how the different pieces that they're now bringing to this. We followed the preliminary injunction, or the TRO, with the Pac-12 issue. So, obviously we're really good at knowing what you need to, the kind of the items you need to hit here in terms of the merits, the irreparable harm, and things like that. So, yeah, I was anxious to see why this changed, and I think that's kind of where you're going to head to next.
Yeah, so I'm going to dig in the next 12 pages. We're not going to read all 13 pages verbatim. That would be boring. Nobody wants to do that. So the next 12 pages, I'm just going to kind of give a summarize, and they're broken up by categories. The first is the background. The court goes through the background on this.
Yeah.
They talk about all the different cases. We have, the O'Bannon case back, 20 years ago or whatever, and a bunch of other cases that the NCAA has continued to lose, continue to show they were operating and, violating antitrust laws. But then also the background talks about how the NCAA acted from July 21 to now, where they opened the floodgates, they let a market be created, and then they tried to step back in and put restrictions on that free market. So I thought that was interesting, how the court decided to talk about these other cases where they had lost, antitrust cases, and talk about what they've been doing since July 2021 to first open the floodgates of the market and then try and put the toothpaste back in the tube and make some restrictions.
And maybe saying they were headed down a better path, maybe not far enough. We can get into that back and forth for forever. But the fact that they were headed down a path and then they went, yeah, no, we don't like that anymore.
Yes.
We're going to change the rules again.
Right in the middle.
Yeah, was the stake to the heart kind of here. So
totally agree. And the court really laid that out pretty good. Basically, kind of set the stage for the NCAA to step on their own throats.
Right.
Okay, so you talked about, all right, before we had a TRO request that was not granted. For this, they're looking at the preliminary injunction, and there's a few factors. There is 4 factors when looking at a preliminary injunction. One is whether the claimant has a strong likelihood of success on the merits. I think they kind of already answered that in the first part when they said it really looks like that they committed an antitrust violation. So, they go through that, the success on the merits, they go through the merits, all that stuff. Substantial anti-competitive effect. They talk about this pretty well in depth about how they created a free market. There is a free market that is operating, and the NCAA is stepping in and basically picking sides, picking winners and losers, telling people what they can do, who they can go through in the market, who they can't go through. And it creates an anti-competitive effect, which was pretty apparent. Okay, so moving forward, the next part in this is whether or not what the rationales were, and if there are less restrictive alternatives.
Right.
So the NCAA was trying to basically give, say, hey, we can offer these other alternatives. We can come up with this other. Our second version of the policy was a less restrictive alternative to having just a total ban on NIL. And basically trying to argue that this would permit student athletes to profit from their NIL, but it failed to show the timing of when a student athlete enters into an agreement, which would basically destroy the goal of preserving amateurism. So I think the court is trying to say they were trying to have it both ways.
Yeah.
They were trying to say, okay, yes, the student athletes can enter into these agreements, they can get money, which is less harmful than banning it, but at the same time, their own arguments didn't really hold up because they kept going back to the idea of amateurism.
Right.
So that was one of the conditions that they discussed. The other thing, and I think you're going to want to jump on this, is irreparable harm.
Yeah.
So in the TRO, it was the reason the TRO was not given was because they couldn't show irreparable harm, because the court stated this was a monetary thing. Like, hey, if you can't get your $4,000 in NIL, we can work this out later, and if it was found that they acted inappropriately, we can give you your $4,000. But in this, I'm going to read one statement here. Okay, so here it is. So the court wrote, with respect to student athletes, however, plaintiffs stand on much higher ground. Although the court previously held that the plaintiffs could not prove irreparable harm because the asserted harm, which was the suppressed NIL compensation, was compensable by monetary damages, it is now clear that harm is not strictly monetary. To be sure, it is pure speculation to assume that the student athletes would receive more lucrative NIL deals in an open market. Fair market value may be equal or less than the NIL deals student athletes can currently receive after selecting a market. But without the give and take of a free market, and that's how all markets operate, the give and take of a free market, student athletes simply have no knowledge of their true NIL value. It is the suppression of that negotiating leverage and the consequential lack of knowledge that harms student athletes. So basically what the court is saying, that you can't just determine it's, hey, they lost out on this one $4,000 deal. It's that you're not allowing them to participate in the give and take of the markets. They don't know their value. And I wanted to get your thoughts on that. I know that's something you wanted to weigh in on.
Yeah. I struggle with irreparable harm. I struggled with it when we were doing the PAC issue, because to me, we're talking about money, right? Like, you're talking about they're going to be out something, $4,000, or the one episode that we did a little while back, you had kids making six figures. I think one was like $1 million or something like that. Student athletes. I shouldn't call them kids. Student athletes. But so I go, okay, we're talking about the value that they're earning to play. That's a monetary value, which is why I understood the TRO, and it wasn't granted because of that. So this was the most important piece for me to read and be like, okay, what changed here? Or how are they getting to this irreparable harm? And then I can understand that. I still struggle with this a little bit because it's still about money. Yes. But it's about money with an unknown answer, right? So yes, it's about money, but there's no market to tell you it's, to your point, $4,000 or $100,000. We don't know what that market is, or we don't know what that value is, because there is no free and open market. And that's what stuck out to me. And you mentioned that suppression of negotiating leverage, that then, there's just no lack of knowledge in terms of what this is. And that's where it gets to. Yep. So it's a little bit broader. Again, I've said in other videos, I'm very black and white. I'm yes and no. This is to me, this is gray, but I understand the gray in it. But this was the piece to me of the whole thing that was the most interesting, because it got them to the point that they would approve, or this judge would approve and grant this preliminary injunction. So
totally agree, and that's yes. So the TRO and a preliminary injunction, you have to show irreparable harm. They were not able to show it to begin with, so this is a huge change.
Yes.
Whether some people may agree with that or not agree with it, it's a huge change from the perspective of the court. And they really laid the foundation in those first couple paragraphs where we read, and in the background where they talked about antitrust violations, anti-competitive practices. They basically showed where the NCAA opened the floodgates and a market was created, and then they tried to step in later and put restrictions on that market, which changed the market. It really did, and that affects the value when you have a free market that's operating and you're trying to put restrictions. it changes what the value, their potential value could be.
Yeah, and to be clear, my hesitation is with both the TRO and the injunction. Not that I don't think the antitrust issues, they talk about the Sherman Act, not that I don't think that's a case that's 100% winnable, or I should say lose. The NCAA is going to lose that case. I totally think they are going to lose that. The irreparable harm just comes into an injunction. Like, I still struggle to get there. I'm not fully there. I mean, you say you might agree or disagree. I don't know where I'm at on it. I definitely know where I'm at on the antitrust piece of it. But this is just talking about a preliminary injunction. So I struggle to get to that irreparable harm piece. I understand the ruling and why they ruled that way. I'm not 100% on board with that, but I understand it, I guess is the best way to put it.
And I think for the layman out there, if you're let's say you have an HVAC business, right? And, there's a whole bunch of new houses being built, commercial buildings, residential homes in your area. And you are not permitted. Some organization or whatever says, hey, you can't come in and bid for these. The irreparable harm comes in because you can't determine exactly how much money you lost because you can't participate in that business. You might say, well, I think if I would have gotten this job, it may have been worth $4,000, but it may have been worth more because other people were allowed to bid. I was not. So, with me bidding, it might have changed the prices, whatever. So that's just kind of a way to think. And again, I'm not necessarily trying to convince, everyone can have an opinion on that or not. But that's basically what the court is stating, is that it had a clear influence on the effect of the market.
Sure. Right. Understand.
Yeah. So the next item was substantial harm to others. The NCAA basically said, hey, you should not give this injunction because if you give the injunction now, but then you rule for us later, there's going to be harm that they can't, it's going to harm some schools, it's going to harm people. And so the court looked at this, they talked about irreparable harm, and they basically said, statement in here says, the NCAA fails to show how such relief will cause any harm that outweighs the irreparable harm that student athletes will face in the absence of an injunction. So that's pretty cut and dry, pretty clear there.
Yeah, that's the piece that stuck out to me, was exactly what you read. You put it on a scale, and the judge is saying the irreparable harm to the student athletes is greater than any other harm to the NCAA or the schools or whatever the case may be. So you put that on a scale, and he's saying, nope, the student athletes have the most harm in this case right now.
Yeah, and so then the last thing that they looked at is public interest. Is it in the public interest to set up this injunction or not? If it's against the public interest, they can decide to not go forward with this. And so the court ruled that encouraging the free and fair price competition of the NIL market by enjoining the NCAA's NIL recruiting ban will serve the public interest. So again, we may not agree with that, but that's what the court ruled, that basically allowing a free market to operate. And that's what I think people need to separate, what they want college football to look like and what they want it to be to what it is. It is a business. It is an industry. And so generally, when you're not talking about college football, something that we've loved for so long and we've pictured it in a certain way, you're just talking about any business or any industry, generally the public interest is served by having a free and open market.
Yeah, and that gets back to the likelihood on merits. They talked about this is commercial in nature, right? Like, again, whether you like that or not, student athletes, amateurism, whatever you want to call it, this is commercial in nature. And because of that, restraints of trade and all of that applies here.
Yes.
So,
and I think, and you and I think, would rather it not be just commercial in nature. I think if we could go back, I think we're mostly in agreement. I think a lot of our fans, or a lot of our viewers, especially the older people that have been watching college football a long time, would rather see it go back to those old days of what it was. But I don't know that that's ever going to happen with the money that's involved now. We've seen the TV and the media companies get involved. It's obviously a big business. It's not just some kids going to school and getting to play a club sport on the side. It is a big, multi-billion-dollar industry.
For sure. Yep. Well, you want to get to the conclusion here, Steve?
Yeah, let's go.
All right, I'm going to, again, throw this up on the screen. You can read along with us in the conclusion here. For the reasons provided herein, plaintiff's motion for preliminary injunction is granted. It is hereby ordered that effective immediately, defendant, NCAA, its servants, agents, and employees, and all persons in active concert or participation with the NCAA are restrained and enjoined from enforcing the NCAA interim NIL policy, the NCAA bylaws, or any other authority to the extent such authority prohibits student athletes from negotiating compensation for NIL with any third-party entity, including but not limited to boosters or a collective of boosters, until a full and final decision on the merits in the instant action. It is further ordered that, effective immediately, the NCAA is restrained and enjoined from enforcing the rule of restitution, which is NCAA bylaw 1211.4.2, as applied to the foregoing NIL activities until a full and final decision on the merits in the instant action. Wow.
Yeah.
So what's that mean?
So there's a couple things that jump out at me.
Okay.
So when I looked at, there was a few media personalities that discussed this right after it came out, and I was kind of watching and listening before I read this myself. And a lot of people were saying, "Oh, this only applies to the states of Tennessee and the states of Virginia because they're the two parties that are suing." Okay. Mm-hmm. For me, and again, I'm not a lawyer, neither one of us are lawyers. As I read this, I think they're very clear on this. There's nothing in here that says in the state of Virginia or in the state of Tennessee. It says very clearly that the NCAA is enjoined from enforcing their interim NIL policy, the NCAA bylaws, or any other authority to basically prohibit or limit compensation. So I think they were very clear on that. Specifically from third-party entities, including and not limited to boosters or collective boosters. So the door is open. Schools cannot pay. That I want to be very clear. This is third party. So schools we still have not opened the door to schools just being able to pay student athletes. However, to me, the NCAA, the court has been very clear that the NCAA cannot enforce any of these policies. And to me, I look at that, this is a federal court. So to me, this is nationwide, everywhere. The floodgates are open. The NCAA cannot enforce any of these policies. And what I thought was really interesting here, which I know this is what they were asking for, it was further ordered that they can't enforce their rule of restitution. Well, what is that? That's the investigations that are going on against the University of Tennessee or Florida, and really any investigations that we're not aware of for NIL violations. They cannot act and try and enforce those in any way. So I think there's two parts of that. There's having the rule. They're not allowed to really even have that rule or tell schools they can't do this. But then they're also not allowed to go through that process of the NCAA investigation, the notice of allegations, the penalties, and all that stuff. So they've basically been neutered, as far as NIL goes. But I think that this is just one other case. We've talked about this many times. The last time they went to the Supreme Court, Brett, I Love Beers, Kavanaugh, warned them and said the next time that one of these cases, you guys are a walking antitrust violation. The next time one of these cases comes to our court or comes to federal court, comes to the Supreme Court, might be the case that blows you guys up forever, that you will not even exist anymore. And so here we are. In my opinion, the NCAA, they didn't need to do this. They were making they were opening their arms towards the conferences and towards the schools of let's come up with a better way to do this. But while they're doing that and trying to come up with a good path forward, at the same time, they're trying to punish and penalize schools for operating an environment that they created, which they opened the floodgates, and then they tried to put the toothpaste back in the tube later, which is an obvious. I mean, any lawyer would look at this and say these are antitrust violations. You can't do this. So they didn't need to do this, but they decided to go forward and do this. Makes no sense to me. And to me, JY, this could be. We had our episode. I said I think the NCAA will still exist in 2030. Right. Well, I didn't know they were going to go forward with this, and this may be the nail in the coffin. We'll see.
I wanted to bring that back up because we did do that first 2030 episode. And even just, that was only 3 weeks ago that we did that.
Yeah.
And things have changed, of course, since then. But I would agree with you. I mean, this is from a United States district judge. Mm-hmm. There's nothing about, these are the plaintiffs in the case, but it's not just for those states. 100% agree. This is nationwide, NCAA, third party you can't touch them. They're
No
hands off. You can't mess with them. You can't have this rule of restitution. They're done skis right now. And this is, again, as you said, this is just for the third parties.
Yes.
This isn't for the schools yet. It's a matter of time. Something's coming. So, hey, I appreciate you walking through this, Steve. Yeah, I saw some of this. I did a brief scan. I know you did the deep dive. So thanks for bringing this to us. Hey, I want to remind everybody, tomorrow, Wednesday, we're going to come out with what we're calling kind of our power ranking, the ACC FSU arguments. So we're going to list where we think the biggest fires are for either side here. Kind of just more opinionated, more discussions from our things. We've been following this from the very beginning. So if you like that, make sure you check us back tomorrow. We'll get that thing posted. And we are going to start doing weekly updates, live broadcasts, focused on the Big Ten, focused on the Mountain West, because that's what we do around here. Spending a lot of time on the NCAA and the ACC right now. But we're getting back to our roots, going Big Ten, going Mountain West. Going to do some live episodes once a week. Be on the lookout for that. We're going to start that here in about a week and a half. And with that, we'll see you next time on the Big Mountain.
Did the NCAA dig its own grave?